Good afternoon, everybody. This is the afternoon session of the Portland City Council. We have one item up. Carla, could you start by calling the roll, please?
Fritz?
Here.
Fish?
Here.
Saltzman?
Here.
Udaly?
Here.
Wheeler?
Here. Could you please read the first and last item?
Agenda item 187, appeal of the Citizen Review Committee against Portland Police Bureau's finding regarding independent police review, internal affairs, case number 2015-C-0104, appeal number 2015-X0002.
Very good, thank you. And I have a rather lengthy script that I'm required to read as part of these proceedings, so bear with me. The council will now take up agenda item 187, scheduled for a time certain to consider the appeal from the Citizen Review Committee of the Portland Police Bureau's finding regarding independent police review internal affairs case number 2015-C-104, appeal number 2015-X-0002. This matter is being heard by council pursuant to Portland City Code section 3.21.160. This is not a public hearing with public testimony. Rather, council is reviewing a decision of the Portland Police Bureau which the CRC has appealed to the council. The council must decide if the PPB decision is or is not supported by the evidence in the record. The council will not hear new evidence and it will not take public testimony. I want to note that members of the council have received emails from the complainant in this matter. These emails are not part of the record and will not be considered, although the complainant will have an opportunity to address us here today. The hearing is going to be conducted as follows. First, IPR will present the case and the procedural history. Second, CRC will outline the basis for its appeal and its areas of disagreement with the PPB decision. 3, the complainant or a representative will have 10 minutes to present. 4th, the Portland Police Bureau will have 10 minutes to present. 5, the involved officer or a representative may elect to make a voluntary statement of up to 10 minutes. Council will then have an opportunity to ask questions of any of the presenters. Council is asked to hold all questions until the presentations of the IPR, the CRC, the complainant, the Police Bureau, and the involved officer are all concluded. Council will then have a discussion. Council may elect to move into executive session for its discussion. Executive session would be authorized under one or both of the following statutes: ORS 192.6602B or ORS 192.6602F. If the council decides to hold its discussion in executive session, an announcement of the executive session and the grounds for going into executive session will be made before the council goes into executive session. 8, following council discussion, I will entertain a motion in second and will vote on whether the Police Bureau finding is supported by the evidence. The Police Bureau finding was, quote, exonerated with a debriefing, unquote. Portland City Code Section 3.21.020S defines supported by the evidence as, quote, a finding regarding a complaint is supported by the evidence when a reasonable person could make the finding in light of the evidence, whether or not the reviewing body agrees with the finding, unquote. 9, if council determines that the Police Bureau finding of exonerated with debriefing is supported by the evidence, the complaint will be closed. 10, if council determines that the Police Bureau finding of exonerated with a debriefing is not supported by the evidence, council will need to decide on the appropriate finding in this case. Council needs to select from the following alternative findings. Unfounded. The allegation, meaning the allegation was false or devoid of fact, or there was not a credible basis for a possible violation of policy procedure. Exonerated. Exonerated. That means the act occurred but was lawful and within policy. Not sustained. That means the evidence was insufficient to prove a violation of policy or procedure. Sustained, meaning the evidence was sufficient to prove a violation of policy or procedure. A finding of exonerated, not sustained, or sustained is based on a preponderance of the evidence. That is, the facts and circumstances indicated it is more likely than not that the violation of policy or procedure either occurred or did not occur. Debriefings may be recommended for unfounded, exonerated, or not sustained findings when it's believed the subject employee would benefit from a discussion and critique of the incident. Pursuant to Portland City Code Section 3.21.160C, no new evidence may be introduced at this hearing. 12, to help protect the identity and the privacy of the individuals involved, during public hearing, council will not refer to them by name, but will refer to them generically as complainant, witness A, Sergeant A, Officer B, and so forth. 13, since Portland City Code provides that no new evidence may be introduced at the hearing, and because this matter involves council's review of a community member complaint that potentially could result in discipline, public comment or testimony regarding this matter will not be solicited or received. So with that, we will now begin. We'll start with IPR, who will present the case and the procedural history. Thank you for your patience.
Thank you. Good afternoon, Mayor Wheeler and Commissioners. I'm Anika Bentalber, Assistant Director of the Independent Police Review. I will provide a brief incident overview and summary of the procedural history of this case before you on appeal today. On September 17, 2014, Sergeant A observed a woman calling for help. The woman told Sergeant A that appellant had just circled her car and was punching her windows. Sergeant A contacted appellant. Police reports indicated appellant was verbally aggressive and kept putting his hands in his pockets, though appellant indicated later when interviewed that he had his hands up and attempted to de-escalate the encounter. The police reports further indicated Sergeant A turned appellant around and pushed him up against a wall to try to handcuff him, but was unable to do so due to appellant's level of resistance. Officer B arrived, warned appellant that he would be tased if he did not comply with orders, and then deployed his taser in drive-stun mode on appellant. Appellant went to the ground but continued to resist. Officer B then deployed a second drive-stun taser in an attempt to handcuff. Officer B then used his taser in probe mode, and the officers were able to handcuff appellant. Appellant complains that the officers used excessive force and excessive number of taser cycle rounds from the electronic control weapon. Now for the summary of the procedural history. I was the assigned IPR director to review this case. This complaint did not originate through the IPR intake process. It was referred by the city's risk management office after they received a federal complaint filed by appellant on March 17, 2015. The federal complaint stemmed from an encounter with Portland Police Bureau officers on the date of September 17, 2014. Portland Police Bureau's Internal Affairs initiated an administrative investigation on May 5, 2015, as part of the routine tort review process. IPR requested that Internal Affairs open an investigation due to the nature of the allegation of excessive force. After the investigation was completed and findings were made, disposition of the investigation was sent to appellant. Appellant was provided with the option to appeal to the Citizens Review Committee, CRC, if dissatisfied with the results of the findings. IPR received appellant's appeal of the Bureau's findings, and the CRC held the case file review of the case on October 7, 2015. At the conclusion of the case file review, the investigation was sent back to Internal Affairs for additional investigation. After additional investigation was obtained, the first appeal hearing was scheduled for April 20, 2016, but was subsequently canceled because Bureau members were ordered not to appear per order from former Acting Chief Henderson. On May 4, 2016, the CRC conducted the second appeal hearing in which they voted 8-0 to challenge the first allegation findings from exonerated to exonerated with debriefing. The CRC voted 7-1 to affirm the second allegation finding of exonerated with debriefing. On May 6th, IPR received notification from Internal Affairs that allegation number 2 would be sent back to Internal Affairs for new findings due to the incorrect version of the Police Bureau directive being used in the findings process. The Bureau accepted the CRC recommendation regarding allegation number 1. On September 7, 2016, the CRC conducted a third appeal hearing for allegation number 2, this time with the correct directive, and they voted 6 in favor, with 2 members abstaining, to challenge allegation number 2 from exonerated with debriefing to sustained. On December 7, 2016, the CRC held a conference hearing with Portland Police Bureau Chief Michael Marshman, and the CRC voted 4 in favor, 1 abstained to continue with their original challenge motion of sustained on allegation number 2. That all leads us to today, as no agreement could be reached between the CRC and the Police Bureau during the conference hearing. An appeal hearing was set before City Council. At the conclusion of this hearing, the City Council must decide whether a reasonable person could conclude that a finding of exonerated with debriefing is supported by the evidence with regards to allegation Officer B used inappropriate force while taking appellant into custody. That's what I have. Thank you.
Thank you. Next up, CRC will address the basis for its appeal and the areas of disagreement with the PBB decision. Good afternoon.
My name is Kristen Malone. I'm the chair of the Citizen Review Committee. I know most of you are familiar with the committee, but for the new faces on the council and in the community, the CRC is a volunteer body comprised of 11 community members. We have several responsibilities, including hearing appeals concerning allegations that members of the Portland Police Bureau have violated city policy. As we review the conclusions reached by the Bureau's initial decision makers, we have the authority to challenge findings that are not supported by the evidence. When that happens, we have an opportunity to resolve these differences through dialogue with the Bureau. In the rare case that the CRC and the Bureau are unable to agree on the proper finding on an allegation, City Codes provides that you all have the final say. This is so rare that I believe this is only the second such hearing in the past decade. So if this procedure is foreign to you, we're all in the same boat. I prepared a short presentation that I hope will give you the most insight. I would have invited questions, but I just heard that we're saving them till the end, so I'm happy to answer them if you are banking them in your mind. For a quick summary of the facts giving rise to the case, which I'm sure you've had a chance to review in detail in the case file, on September 17, 2014, several PPB members dispatched to a Northwest Portland intersection following a report that a cyclist, the appellant, had struck the window of a motorist while stopped at a traffic light. Sergeant A contacted the appellant first, followed by officers B and D. After the appellant began shouting and emptying his pockets on the ground, the officers took steps to restrain him. The three officers worked together to push the appellant up to a wall and tried to handcuff him, while the appellant struggled against the officers. During this time, Officer B issued a taser warning and discharged his taser 3 times in rapid succession in the appellant's back. After these initial discharges, the appellant fell to the ground. Sergeant A and Officer D were on top of the appellant's upper body, and Officer B worked to stop the movement of the appellant's legs, which at one point knocked Officer B to the ground. While the appellant was on the ground, Officer B placed the taser directly onto the appellant's calf and released a 4th charge of electricity. As the Bureau members continued to work to handcuff the appellant, Officer B fired the taser's probes into the appellant's back, issuing a 5th activation of the taser. Sometime later, Officer B again discharged the taser, this time apparently by accident. The probes were still attached to the appellant, and the taser log registered an activation of up to 1 second. The Bureau investigated several alleged policy violations relating to this encounter, but the only one remaining for consideration today is Allegation 2, which charges that Officer B used inappropriate force in taking appellant into custody. The Bureau found that Officer B's uses of the taser in this incident were lawful and within policy. However, it recommended a debriefing to counsel Officer B on the design differences found in the new X2 taser model he was using, which the Bureau believes led to the last accidental activation. The CRC reviewed the record and held a public hearing to determine whether the Bureau's finding was supported by the evidence. In other words, we, like you, evaluated whether a reasonable person reviewing the evidence in the case file could have concluded that Officer B's uses of force were lawful and within policy. The particular policy we evaluated was a December 2013 executive order regarding Directive 1051.00, which provides rules for the use of electronic control weapons, or tasers. At an appeal hearing, the CRC concluded that the evidence did not support the Bureau's finding and voted to challenge. The CRC recommended a finding of sustained and continued to do so after a conference with Chief Marshman. All of the CRC members who voted and did not abstain agreed that Officer B's conduct was not in line with the directive. There were 3 main areas of disagreement with the Bureau. First, CRC members felt that the first 3 uses of the taser were not supported by the directive because appellant's conduct did not meet the definition of active aggression. Although Officer B and only Officer B reported a feeling that the appellant might punch Sergeant A, CRC members found that the evidence showed that the appellant was merely resisting the officer's attempts to restrain him. 3 officers had the appellant pinned against a wall and had hold of his arms and torso. Therefore, a reasonable person would have determined that there was no, quote, threat or overt act of assault coupled with the present ability to carry out the threat or assault, unquote. Further, some members found that the directive did not permit the 4th and 5th taser deployments, which occurred after the appellant had been brought to the ground and had 3 Bureau members on top of him. Section 3.2 of the directive states that, quote, members will not use an ECW on a handcuffed or otherwise restrained subject, for example, a subject being held to the ground by multiple officers, unless the subject is actively engaged in behavior that creates a substantial risk of injury to the subject, members, or others, and no other reasonable force options exist. The video in the record showed that the drive stun to appellant's calf occurred while the appellant was on his right side. Officer B had gotten hold of the appellant's left leg and was kneeling on his right leg, while Officer D pressed on appellant's torso and Sergeant A straddled across his shoulders and held his left arm. Seconds later, when Officer B deployed the probes, appellant had been placed prone on his stomach and appeared well controlled, with Officer B straddling both legs with a knee on appellant's buttocks, while Sergeant A was seated straddling the appellant's lower back. Sergeant A was holding the appellant's left arm and Officer D was holding his right arm. CRC members felt that Section 3.2 specifically prohibited the use of the taser in these circumstances because appellant was well restrained. The circumstances in this case directly track the example in the directive of a subject being held to the ground by multiple officers. CRC members disagreed with the Bureau's conclusion that the taser activations were justified because the appellant was kicking his legs immediately after being taken to the ground and trying to roll over. Some felt that these acts did not rise to the level of active aggression. In any event, the video showed that the appellant was manually restrained and no longer kicking at the time of the activation on his calf, and that he was prone and largely immobile when Officer B deployed the probes. Therefore, with respect to the 4th and 5th cycles of the Taser, CRC members found that the evidence did not support a finding that the appellant posed a substantial risk of injury to himself or others, or that the Bureau members lacked other reasonable force options. Finally, the CRC took issue with the final Taser deployment, which occurred after the officers believed the appellant to be effectively restrained. This activation was recorded in the Taser log, but was not reported by Officer B because he was unaware that it took place. The Bureau believes that this accidental activation occurred because the Taser's activation button is placed along the side of the weapon in a similar location to where officers are trained to rest or index their fingers on their firearms. The Bureau has noted that the Taser Officer B was using was not the Bureau's standard-issued Taser, but instead a new model called the X2, which the Bureau was trying out at the time, and which has now been formally adopted. The Bureau has suggested that the officer's instinct to index his finger instead caused him to tap the activation button, sending another charge of electricity down the attached wires. The CRC found this information useful in understanding how this accident occurred. However, Directive 1051.00 is agnostic as to the particular device being used. It applies to electronic control weapons generally, including the one being used on duty by Officer B. The CRC is not aware of any rule that would suspend the general force guidelines when new weapons are being tested in the field and used on civilians, and rightfully so. Community members have a right to expect that officers are properly trained on any weapons used outside of the training facility, and that in all cases, weapons use will be governed by the Bureau's force and ECW directives. The Bureau has also contended that Officer B should be exonerated with respect to the 6th activation because it lasted only a short time or because it may not have had an effect on the appellant. On the second point, the Bureau characterizes the appellant as not remembering that discharge. But in his IA interview conducted nearly 8 months after the incident, the appellant reported feeling more than 3 charges of electricity during the incident, and he was not asked any follow-up questions on the precise timing of those shocks. In any event, there's no language in the directive allowing otherwise impermissible uses of force based on the duration or amount of pain felt by the citizen. Therefore, CRC members found that the 6th discharge was not justified by the directive and that evidence did not exist to support this use of force. In conclusion, while I've outlined a number of explanations that animated the CRC's challenge, Council has the opportunity to adopt any, all, or none of them in answering the same question using the same standard, which is whether a reasonable person could conclude, based on the evidence, that the force Officer B used when taking the appellant into custody was lawful and within policy. Thank you.
Great, thank you. Next up, the complainant has 10 minutes to present. Or if I understand the rule, the complainant's representative. Good afternoon.
Good afternoon. If it pleases the council, a couple things I've heard so forth.
First, we need your name.
Sorry, my name is Matthew Klug. If it pleases the council. To start with, I saw it piqued your interest. I did file the tort on the 13th of March. It was a Friday the 13th, so it's within the 2 years, or within the 6 months, 180 days that it needed to be filed. The date was given wrong prior. Also, there was no dispatch to the officers. So just to be clear that you can go and look at the paperwork, it says self-dispatched, handwritten on the paperwork. There was no 911 call either. So this has been mischaracterized yet again in the stuff you just received yesterday or the day before. There was no 911 call. The word call was used in the paperwork, but that was supposedly a verbal call with her, with the alleged victim with her arms out the window saying, "Help, help." That's what this is going off of. Okay, just to start it. It took about 3 minutes between when that happened and when I was in handcuffs. 30 seconds of it is the video. Literally 3 minutes. Okay, this has been characterized as this big thing. It's been 890 days since that occurred till today. Okay, the Tort Review Board asked for review on April 28th, 2015. It's now been 667 days since that occurred. And the target is supposed to be 180 days. So just to put this in perspective, I'm talking about a lot of big issues, but really it's down to the policy at 1051 that I provided. They tried to, at a hearing, present one that was prior and an older version. And on the way out of the hearing, when they won that, apparently won that, they, down to the commander at the time, Bob Day, and some other people, they were high-fiving Darrell Turner on the way out the door. This has just been, you got to kind of look at the way they've behaved, guys, okay? This is going on still. They're trying to mischaracterize this still, and I'm wasting my time talking about this. So I'll get to what I need to say here. My name is Matthew Klug, and I'm a resident of Portland. I'm an epileptic. I'm a survivor of traumatic brain injury from a long time ago, and I'm a coma survivor, and I suffer mental illness. I'm not a lawyer, but I'll explain what happened to me to the best of my ability. These things kept coming to decision points, and decisions were made that kept making this compoundedly worse over and over and over again. This has been 890 days, and I'm still shaking about it now. Really, I have a press release from the auditor's office, and I gave copies to the clerk. This is from January 27th, wanting to get to the bottom of how the Portland Police deals with Brady material. I've got an example right here. After I sued the city and the county, it turns out there was no complainant, but they never put that in the discovery packet, Nick. That's a big deal. And it scares the hell out of me. This is a 1963 Supreme Court decision, and no one's paying any attention over here at the courthouse. I'm calling out to the judges, somebody pay attention. In their name, they tried to arraign me in absentia. One of the judges put her foot down, thank God, okay? They tried to arraign me on a bunch of felony counts, 7 counts. They left me in jail. They didn't do it by closed circuit. They didn't do it by video feed. They left me in jail. Now, it's a good thing my parents showed up and a family friend who's an attorney, because if I'd had a different judge or didn't have anyone there on my behalf, I might have been arraigned on 7 felony counts at that point in time. I went home 12 hours after I had the charges dismissed. So, I was never read my Miranda rights, and I was put into general population. You know what kind of searches they do before they put you in general population. So I was searched in different ways before I was put in, but I was never read my rights. Okay? They kept me in jail for another 12 hours after the charges were dismissed by the judge. What's going on there, guys? These are, big issues. I'm sorry to just lop this on you, but to cover up for some kind of like little accidental taser thing, that just kept making just really bad decisions, and this just kept piling on and piling on and piling on, to the point where I literally was given another set of charges 43 days later. I don't know where their origin came from. I spent $9,000 on a criminal defense attorney to try to keep me out of jail long enough to file this case that I did file on Friday the 13th. And that's just one of the oddities of this case. But the evidence that there was no complainant wasn't in the packet, okay? So there was discussion of the charges, but there was no ability to find out the origin of the charges. They were just there 43 days. They must have refiled them. I'm not a lawyer. How did this occur? So I know when they no complaint things, they can go refile them later if they want to. But, was there some kind of other something in the decision making, a risk management decision? I'm not sure along the way what contributed to refiling the charges. So, and at some point, I know it's not double jeopardy, but it comes right up to the line. And now they're going to go after me, and they're probably going to try to arraign me or, try me in the court of public opinion. And wow, so this is their third attempt at it. And I hope he takes that with a grain of salt. So, I know you've read this, and here's the 1051. If you need a copy, I got one for you. Here's my lawsuit with the general allegations in it. I'm sure you've all read this. I don't know what I might have left out, but trying to arraign someone in absentia is just crazy in the United States of America. Take that in, just sitting there in jail. I knew I was supposed to go at 8:30. I never came with any medication. The nurse came every 4 hours. They knew I was epileptic and I required medication. Didn't get any medication for 24 hours. Had to go they took my $17 and had to go, get $20 out of the bank because they give me some debit card instead of my cash back and get a bus ride home, and I have a seizure before I even get in the door, So this stuff is a big deal. They have some kind of agreement with Rite Aid. All they had to do was send someone down there. I know it's the county and this isn't but at some point this is intersectional in that when you hand these people over, you've got to have some faith that they're not going to be mistreated again and again and again. And so the sergeant who pulled me over, Sergeant A, pulled me over. I pulled over a block after I heard a boop, boop. So, I turned left at a light. I had the green left arrow. And it must have been red for him because I heard the thing. I looked back, there were lights. A block later, I pulled over. Where I pulled over, which is the campus of Northwest College of Art or whatever it is. And the old federal building. And I have a post office box across the street that I've had since 2005, over 10 years I've had a post office box there, So it's not like I'm a stranger to Portland or downtown, or that's where you used to get your tax forms, guys, This is Portland, right? What's going on? So I'm just out for a bike ride. It's a little heavy-handed. He came out of the car, reaching, unbuckled his holster, and slid back the cover. Now, that should scare at anyone. And it did me. I put my hands up in the air and I said, and the witnesses in the paperwork heard me say verbally, "What did I do? What did I do?" I didn't know what his animus towards me was, so I said, I didn't, maybe I'm close to the bus station, so I said, "I'm not homeless." I don't know why I said that. I thought that perhaps he'd lighten up. And the officers came right after that in the old gold unmarked car. And I believe those are the enhanced crisis intervention team members. They did not de-escalate. The first thing they said to me was, "Turn around, turn around." I turned around, and the sergeant did not try to cuff me. They all came at me at the same time.
Thank you very much.
The rest is on the video.
Thank you, sir. Appreciate it.
By the way, you're probably wondering, who am I? My name is Eric Terrell, and I'm the appeal process advisor. Basically, assist the appellant in any way possible. So that's why I was sitting with the appellant.
Thank you, sir. Appreciate
Welcome.
it. Thank you both. Next up, the Portland Police Bureau will make its presentation. They also have 10 minutes. Good afternoon. Please state your name for the record.
Good afternoon, Mayor, council members. Mike Marshman, Chief of Police.
And I'm Jeff Bell, Captain of Internal Affairs.
So thank you for the opportunity today. I will try very hard to get my presentation completed within 10 minutes. Captain Bell is going to help along. Part of the slides I think you'll be able to view as we go through this are going to be a little bit redundant as other folks have testified and spoken to them, so I'll just skip through those as we go. So we shall begin. So as stated earlier, the Taser policy in question today is Directive 1051. Active aggression, I believe, is what we're talking about today, and that is a threat or overt act of an assault through physical or verbal means, coupled with the present ability to carry out the threat or assault, which reasonably indicates that an assault or injury to any person is imminent. For the next slide, when reasonable under the circumstances, members are authorized to use the ECW or Taser in the following: in response to active aggression, and second, in drive-stun mode, in the event that the probes are insufficient spread or dislodged, in close quarters, like you'll see in the video, to protect a member, create safe distance, or avoid the use of a higher level of force. And to avoid the higher use of force, I think, is appropriate in this instance. Members will not use a taser on a handcuffed or otherwise restrained subject. And in our policy, we give the example of a subject being held to the ground by multiple officers, unless the subject is, again, actively engaged in behavior that creates a substantial risk of injury to the subject themselves, member or others, and no other reasonable force is available. So the reasonableness standard, as was said earlier, the CRC may find the outcome of an administrative investigation like this unreasonable if the committee finds that the findings are not supported by the evidence. I think it's important to note here that the RU manager who wrote the finding, their standard is the preponderance of the evidence, or like a greater weight of the evidence. And that standard that the RU manager uses is a little bit different than the CRC's reasonable person standard. So I went through that pretty quick, but I wanted to get to the video for you, and during the presentation we'll show the video a couple of times. So if you're ready, we can show you this encounter. And hopefully technology will work. It's a short video. Throughout the presentation, we'll come to it a couple times. One thing to note, and you'll see it in some videos, you'll be able to see it a couple times. The taser, you see that little flash, that's like the taser going off. In the drive stem mode, if it's raised up higher, it registers a cycle. The computer chip in the taser registers that, but doesn't register that it's making contact or if it's effective. So in a drive stem mode, my assertion is if it's up in the air, and you'll see in the successive videos, it's going, but it's not contacting. And then again, not to get too technical, but that new taser, the Bureau has since adopted it. The Officer B, was testing that, which we do with a lot of tools we deploy in the street. When you index your finger, which we train to, there's a button right there, which is how you activate that in drive stun mode. One of my assertions is when you're struggling, like in that video, when he's getting kicked and rolled over, he's by default clenching because you're getting knocked over. I think he's hitting that button, and that's when you can see the flashes going off. Hopefully, as we proceed further, that'll be a little more clear. So the next slide's background to the call. I think we've been over that from other testimony. Officer B's statement, it's what he observed. Sergeant A was being yelled at. Complainant's hands were moving rapidly. Officer B believed that the complainant was about to engage Sergeant A in physical altercation. That's what led Officer B to move in and start taking some action. The next statement, as I approached, this is all quotes from Officer B. He notated that complainant was intensely focused on Sergeant A, continually yelling at him, thrusting his hands in his pockets, lowering his head. And from Officer B's training experience, he believes this behavior indicates a person is initiating the physical altercation with Sergeant A. And then again, here's what we call clip 1, so you get to see this again. This is the initial contact. So Officer B goes on with his statements. He believes Sergeant A was struggling with the complainant. Complainant was arching him back and pushed against Sergeant A. He thought he was going to try to punch him. So that's when he gives the taser warning. Officer B believes the complainant was violent and it continued to escalate. Officer B says the taser was initially effective in deterring the aggressive behavior. Complainant drops his knees and begins kicking his feet. And seeing the officer get kicked over, to me, is active aggression. Officer B says he got kicked multiple times by complainant, causes him to fall to the ground, and he believes the complainant is still struggling. So the last video you saw shows that and what I believe is to be active aggression by the complainant in the first 5 seconds of the taser. And again, that taser button is pushed 3 times for 3 seconds, 1 second, and 1 second. I believe not all those were having contact with the complainant, but the officer, rightly so, was holding on to that because you don't want to lose that taser. So yes, it does register those, but I don't believe all 3 of those had contact with the complainant. And again, another video for you, sorry, to watch. And the video, in the video, I'll get to that in a second. I'm just kind of watching the time here for you. The video shows Officer B gets up after being kicked, employs the taser in drive stun mode again for the 3 seconds. Complainant still kicking and struggling. Basically, they were just trying to get the complainant into custody. I have one more video clip for you, and I'll get to the CRC's concerns. Thanks. So the next slide, the taser probe. Officer C, the second bullet point, she would be on the complainant's right side. She believes the complainant's overpowering her and she can't get control of his arm. And then as you watch this next video, you can see the complainant try to do a push-up. It's a little bit hard to see his right arm. She's struggling, just can't get his arm behind him. So he's not in control. Well, I'm running out of time. I'm going to skip towards CRC concerns. CRC concern number 1. Officer B's use of taser was unreasonable because his use was not in response to active aggression. I essentially, my assertion is during a video, I believe complainant is in active aggression with punching or attempting to punch Sergeant A, kicking the officer, and having the officer fall to the ground. For CRC concern number 2, being restrained since he was held down on the ground by officers during a taser application. Yes, we were holding him down, but he wasn't restrained. He continued to fight and kick. The sergeant was struggling to get his right arm. In one of the videos, you could almost see him start to do a push-up with the officers on him. And again, Officer C wasn't able to get control of his right arm. And CRC concern number 3, they didn't believe the last discharge of the taser was supported by the evidence. After the complainant was handcuffed, he was still struggling. And you have to take control, maintain control of that taser. He's still struggling even though he's handcuffed. Again, my assertion is, though nobody recalls it, I believe that taser application, it's due to the trying to control that taser. So for PBB findings, well, you've read that. I'll just finish up with seconds left. Again, when that taser light goes off in the video, it's not necessarily a contact with a complainant, though it does register in the taser download. Fast.
Thank you.
Thank you very much.
Next up, the involved officer or a representative make a voluntary statement of up to 10 minutes if they choose to do so. Then the council may now ask questions of any of the presenters.
Mayor, how do you want to do this? Do you want to invite the presenters to come back just so we can do it as one panel?
Why don't we do it this way? Why don't we find out what the nature of the questions are, and then we can invite panelists up individually
So I
to
have a
answer
number
those
of,
questions.
I have a number of clarifying questions I'd like to ask the chief.
Chief, can you come on up?
And I have a couple procedural questions about CRC that I think I'd address to the chair afterwards. Chief, thank you for your presentation. And we were given a very thick folder with a lot of information. And my understanding from a prior conversation I had with Mr. Handelman is this is the first time council has had an appeal like this since 2003.
Yes.
So no one, with the exception perhaps of Commissioner Saltzman, has been through this before. So the rest of us are learning on the fly. So I have just some basic questions. From the moment the officers had contact with should we call him the complainant at this point? The complainant. How long did it take to get the complainant into custody?
I don't have that specific time frame, but I believe that video that you saw, it's obviously towards the beginning. He wasn't handcuffed at the end of that. I assume he's handcuffed fairly quickly after that. So
this entire
15,
encounter
20
lasted
seconds.
how long?
I'm guessing, I can pull up the video, maybe 15, 20 seconds. It's fairly brief.
Okay. Is it relevant to your analysis that there were 3 officers involved?
Very much.
Excuse me, three police officers that were engaging the complainant.
Yes, sir. Very relevant.
And at what point would the number of officers involved begin to change your the way in which you view restraint or whether other kind of force was warranted? I guess the point I'm trying to get at is the difference between having a single officer trying to subdue someone and a large number of officers. And how does that change the analysis?
If it's just one officer and one subject, I think the probability for either party to get injured is greater. With two officers and one subject rather, it's going to diminish. We actually train, if possible, with 3, because I believe with 3 officers and one subject, again, the probability for any of those involved to get injured lessens. With one, like in this encounter, you could have one officer trying to control one arm, another officer another arm, and a third officer trying to control the legs. That's actually how we train. I do believe, to a point, more officers correlates into safety for all the parties.
That's common sense, right? I mean, you have
Yes.
a number of officers trying to subdue someone, then it changes the balance of force, if you will.
Correct.
Is an officer required to give an oral warning before discharging a taser?
Yes, if time allows. So there is a little caveat there, but generally speaking, yes, they are.
And I'm just picking up on this because it was part of what you testified to counsel. And your understanding is that a warning was given?
That's correct.
And is that in dispute in this hearing?
Not to my knowledge, no.
And under what circumstances, again, could someone be relieved of the obligate duty to give a warning?
For safety reasons, if it's simply if no time allows, obviously not in this case, but if somebody pulls a knife and starts running at you, and if you think a taser is going to be effective, you're not going to take the time to say, drop the knife, or I'm going to tase you, if they're actively advancing on you as a hypothetical.
Chief, one of the terms that you've called out in the directive that's before us is the meaning of the phrase active aggression.
Yes.
And I guess just in terms of interpreting that and applying that concept to the facts in this case, how much of that is an objective standard and how much is a subjective standard? And what guidance do you have for us in terms of the interpretation? Because to me, there's an objective and a subjective component, but I don't have a clear sense of either.
Okay. Well, in this specific case, Officer B, when he's down by the legs of the complainant and the complainant's kicking hard enough to knock the officer over, to me, I think that's a clear example of active aggression. He's struggling. He's fighting. Later on in the video, when he's trying to do a push-up, and you can see it better on his left arm, to me, that's active aggression of you're not allowing the officers to put you in handcuffs. You're obviously not complying, and you're trying to get up and get away. What would example of not active aggression mean? If you're intoxicated, let's say, and you're stumbling and you're just pulling away from the officer, but not too hard. I mean, it's a little bit of a sliding scale. There's some resistance there. I wouldn't say that's active aggression. I mean, to me, I think watching the video the first time I saw it, when the officer gets kicked towards the wall, frankly surprised me. I mean, that's a pretty good kick to do that to that officer.
You talked a little bit about the duty to avoid a higher use of force. Now, in this particular instance, what would have, give us an example of a higher use of force beyond the use of a taser? A
couple uses of force that, in my mind, would be a higher use of force would be strikes or punches to the complainant, higher likelihood of complainant being injured and/or the officer, or the use of the aspeton, striking the subject with a metal stick, I think would be a higher use of force and more likely for the complainant to get injured by that. With a taser, there's no residual. It changes the person's, it can, when appropriate, changes their active aggression stance at times. Instead of trying to get away, it gives the officers a few seconds to handcuff the subject. I have been tased. It hurts, yes it does, but once the taser charge is over, there's no residual impact. I believe that is a lesser amount of force and less likely to injure the complainant versus punches or strikes or hits with the aspeton.
Chief, is that hierarchy of use of force clearly set forth in the rules?
Yes, it is, and in training.
And in training, and it makes clear that the use of a taser is that there's a higher use of force that follows that. It includes punching and use of a baton and other tools.
Yeah, we've moved away from the levels of continuum, but that is correct. I mean, actually, to me, the drive stun mode is even more minor, if you will, than shooting the taser probes. That wasn't affected the first couple of times, so then the officer, because each time you use it, you have to assess whether or not it's effective. After 2 times, it's not being effective. The officer tries to use the probes because that greater spread has a, if done correctly, has a greater impact on a subject. So the officer, in their minds, working up that scale.
So Chief, I have one other question, then I'll come back after my colleagues. But so we are being asked to apply a reasonable person standard, and a reasonable person, when confronted with the facts in this case, I think would ask a basic question, which is, why did it require 6 different uses of a taser to subdue a person, particularly when there were 3 officers and 1 person? And that, on its face, I think, is a question that people would ask in this case. What's your response?
2 points. One, I think it's a very reasonable question. The officer thought they activated the taser 3 times, though the computer chip in the taser, when you do the taser download, indicates 6. So the officer thinks, in his mind, he has to use it 3 times. Again, in the video, when he's holding on, they're struggling. My assertion is he's hitting that button on that taser he was testing, and it's going off without having contact with the complainant, and the officer simply doesn't know it. That's, in my mind, where you have the discrepancy of the officer thinks it's 3, but in reality, it's activated 6 times. But again, It's not 6 times, in the way I read the reports and view the video, it's not 6 times on the complainant. To your other point about the reasonable person standard, I believe it was already mentioned, but if not, I mean, the Assistant Chief of Operations, the person who wrote the finding, the Internal Affairs Captain, and the IPR Director, or their designee at the time, all concurred with the original finding, which is the higher level that they have to review this at, where CRC views it at the reasonable person standard. So you made 2 points there.
Yeah, you lost me in that last point there. So you're saying the IPR director believed the higher standard than the reasonable person standard?
Well, at the time, all those folks I listed, they have a different level of review, a different standard, and they all affirmed exonerated with debriefing before it went to CRC.
I'm a little confused trying to follow how many people were involved in this. Obviously, Sergeant A started it, but then Officer B and Witness Officer C arrived. And then there's a Witness Officer D and a Sergeant E. So what would be described as a witness officer?
Somebody who just viewed and didn't have any physical interaction with the subject.
But then it says that Witness Officer D positioned herself on the left side. So is there a protocol that you always call in other officers who are just going to be witnesses?
No.
And so if the issue was 3 people not being able to restrain the complainant, why were there then 2 witnesses just taking notes rather than helping to secure the person?
So I can explain real quickly. In the context of these cases, the involved members are the members who actually have allegations of misconduct against them, and officers that don't have allegations of misconduct are called witness officers. So in this case, there was no allegation of misconduct against Officer C. Even though she was involved with the incident, she's called a witness because she is a witness to the allegations of misconduct on the part of Officer B and Sergeant A.
Yes, I guess my concern is I'm having trouble following who's what. So if a person is having an altercation like this, it might be difficult to recognize who's been hands-on and who has not. And it seems like the CRC focused a lot on the use of the taser and how much that was used. Was there consideration of the initial putting the subjects against the wall and basically going towards him when it started with a traffic argument?
Yeah, so Sergeant A had allegations against him, but all those allegations were, I believe, exonerated.
And the CRC affirmed that.
All right, I'll ask them when I get back up again. Thank you.
I just want to make sure I'm understanding the sequence of events. So he was followed down the street, the lights went on, he dismounted his bike, the police car pulled up, he pulled the bike onto the curb, and then he was ordered to do something. His hands up, or turn around. And at that point, the taser's deployed for the first time. Is he standing or not standing?
No, you wouldn't trust that?
Yeah, sure. So
You could walk me through.
Yeah, so you've got a pretty decent, just kind of general description. So once they tell him to turn around, their objective is to kind of use the wall to push him up against the wall and then take him into custody with his hands behind his back. And that is the point where Officer B, who is actually riding in the car with Officer C, when they come up is right when the video starts. They're engaged with them up against the wall. And Officer B says in his report and in his statements that he saw one of the complainant's hands back in a fist, and based on his observations of what he described as kind of violent behavior and aggressive speech, shoulders rolled forward. He took that, and actually in answer to Commissioner Fish's earlier question, those are kind of the objective things that he took in. His subjective belief was that the complainant was about ready to strike Sergeant A, and that's what caused the first application of the taser.
But there was no violent behavior, there was aggressive behavior, right? I mean, he didn't punch anyone or...
With the officers, not at
Yeah.
that point, no.
So the first taser
Activation.
is he still standing?
Yes,
Okay, and then he falls to the ground.
yes.
Okay. And then there's a struggle, arms and legs, but there's two more activations, one in the calf and one in the back. And those are the two I'm confused about because he does seem subdued at that point. So I just want to make sure, because the video is, it's hard to tell what's going on in the video, so.
It is hard, and I apologize. I probably have like 30 hours in reviewing this case, and
Yeah.
to give you a fairly detailed presentation in 10 minutes is a little bit of a struggle.
Understood, yeah.
So, the kicking on the ground, the pushing up off the ground, I mean, he's not compliant and being placed in handcuffs. The actions that he's doing, not obeying commands, not obeying orders, and all the physical movements with that. Again, it's my assertion and others as well that is still active aggression.
Okay. Okay.
Chief, I have a couple
Could
more.
I just follow up on Commissioner Daly that it says in the record, though, that people were actually sitting on him at that point while he was face down.
We could watch the video again. I mean, at one point, Officer B tries to get on his legs after he was kicked. So one way to safely do that is you could trap somebody's legs and sit on them to avoid getting kicked. Sergeant A is trying to get his left arm behind his back, and Officer B, she never really got control during the video. She's trying to get his right arm behind his back. So Sergeant A, Officer C are not sitting on him. Officer B is on his legs trying to keep from getting kicked again.
May I ask a question here? Because germane to this. So there was some discussion of the definition of restraint.
Yes.
And it sounds to me like there's a dispute here between the police and the CRC about whether or not this individual was restrained.
Correct.
What's your view again, and where do you see the difference between the CRC having heard their testimony?
And having listened to CRC that night, again, I have no faith that if either Sergeant A or Officer C let go of the complainant's arm, that he was just going to put his arm behind his back and calmly be taken into custody for the incident in question. I believe he would have tried to either punch based on previous actions of the complainant seconds earlier, either try to push up, get away, and still punch, or I think he would, if he could, try to get away from the officers. So I think he's taking steps forward to accomplish his task versus obeying commands and being taken into custody. I saw no indication that he was complying with the officers.
And you said this took place over a fairly quick period. I think you said 15-ish seconds, something.
A little bit longer than the whole length of the video
longer.
you saw. Yeah.
So what should I expect if I am being tased some number of times greater than 3? What's my state of mind? Am I in a position where I'm hearing what you're saying? I've never been tased, so I'm just asking the question. What would you expect in terms of compliance?
Sure. So when I was actually working the street, I have tased folks. Every time you activate the taser cycle, the officer has to reassess the effectiveness of that taser. After 2 drive-style modes, if it's not working, you shouldn't do a third. You got some other tool needs to happen or different use of the taser. I have been tased. I've talked to many folks as I am trying to take them in custody. They're able to hear and comply if they so choose to.
You testified that the officer believed he used the taser 3 times, but the facts show it was deployed 6 times. Does that interfere with the argument you're making that there is a waiting period between those tasings to reassess the situation?
The main issue with the number of tasings and where the discrepancy comes in, the first 3 tasings were 3 second, 1 second, and 1 second. They all occurred in a 5-second span of time. The way the taser measures, just to get a little bit technical, it won't measure anything less than 1 second. So if you have 2 half-second taser activations, they will both show as 1 second, and both of the 1 second taser activations happened during the same second, which I think it's fairly reasonable to assume that the officer is applying one, but his finger is kind of bouncing on the button a little bit as he is applying it for approximately 5 seconds.
Does that meet the standard then, 1 second, 1 second, and 3 seconds? Does that meet the standard you're laying out in terms of reassessing before reapplying?
I think in this case, based on what the officer said, I think it's fair to assume that the officer did believe that this was only one activation. And during the struggle, like I said, his finger was coming off the button. This was a new piece of equipment, and I don't believe he knew that there were those gaps in there, thus believing that it was one single activation. So,
Right. And you raised this testimony, so I'm asking it, even though it may not be especially germane. Is there training prior to sending new equipment out into the field?
yes, there is.
What happened?
Well, one, I think, in my mind, it's a poor design of that button on a taser. When you use a firearm, and a taser is shaped like a firearm, you keep your finger out of the trigger guard. That's just basic weapon safety. It just so happens, they call it indexing your finger. When you index your finger, it just so happens on this taser, that's where that button is. So during the video, when you see that flash go off and that drive stem mode, but the taser is not on the complainant, if you're struggling, you have a natural instinct to kind of clench your hands during that struggle. My assertion is when you do that, your finger's moving and you're bumping that taser. That's why I don't think the officer realized he was hitting that for a second at a time. That's why I think there's a discrepancy between the 6 activations, though again, doesn't necessarily mean they were effective or on a complainant, and the officer's mind that he thought he activated it and applied it 3 times.
But surely not using a weapon in compliance with its instructions. That's a problem, isn't it?
Well, when you're trying to hold on to it, and if by holding on to it, you're actually hitting that button, again, that's where I default back to the design. So when I took this position, and then when this case came to me, because it's gone through a couple different administrations and different people, I asked the training division, let's review this taser at large, because I think it's potentially problematic.
And surely even using it in a situation where that might happen is problematic. If you're struggling, because the CRC brief actually does say, witness A, Officer D, Sergeant A, restrained appellant's arms, knelt on his back, Officer B straddled appellant's legs. And I think that's what I saw in the video. Why would you then be using a taser in close quarters about that?
Because I think he was still struggling. They did not have control of him. And then I believe it was Commissioner Fish said, what other options would there be? I would rather have the officers use the taser with no residual effect versus any kind of a strike with their hands or knees or pulling out the baton and hitting them with a metal stick. I think that's problematic. If they punched him or used a metal stick, my question would be, why wouldn't you have used a taser? So I think the taser's a lesser probability of harm to anybody involved.
Can I pick back up on the question of the taser? In terms of a piece of equipment, Chief, how many times can it be discharged?
That specific taser, I mean, the taser itself? Yeah. So this new taser, like the one used in this incident, it has 2 separate probe cartridges.
This is the so-called X2 taser.
Yes. So it has 2 cartridges and each cartridge has 2 probes. So you can fire the 2 cartridges independently of one another. But for the drive stun mode, where you're not discharging anything, it's just a contact mode. There's a number of times there is, it could just cycle and cycle and cycle. So it's two different ways to use that electronic control device.
And do we currently have any guidelines that deal with the frequency of use?
Yes, in our patrol tactics, if you use since that weapon specifically is what we're talking about, if you use it in drive-stun mode a couple times, you're not getting a desired effect. Excuse me. The officer should be thinking through each one and realize what they're trying to do isn't working and reassess on what they could do to, in this case, effectively take somebody into custody. So they need to always kind of assessing and reassessing what they're trying to accomplish, and whatever tactic they're using, is it effective? If it isn't, they better be thinking differently on how to do something that will be effective.
Can you explain the two different modes of use with probes and without? I also have never been tased, so.
Yeah, so I apologize up front if it's a little technical. So you have two modes. You have a drive stun mode. So, excuse me, the end of it's maybe 1 inch by 2 inches roughly, and it's just a contact. So if I place it against somebody's arm and touch that little button for a second, they'll have that contact for a second. It's going to hurt their arm. You pull it away. Zero residual impact of that. Doesn't affect the rest of their body at all. So it's lesser level of control, if you will. The second way to use it is if you have some distance, you can discharge two probes and actually make contact with you. So I could hypothetically shoot something, hit like a forearm and an upper arm. Those two probes where that contact is where you get that electricity through. That effectively isolates the larger muscles just in the arm, and it's harder to use your arm. But the rest of you is still free to do what you choose. And yes, it hurts. I mean, I've been tased. As soon as that electricity stops, you have no residual, full motion, game on again.
Excuse me, though,
Yes.
what you just said is not in the record, right? That's not part of the evidence for this hearing.
The officer did use
Description of how a
probes.
taser works. Because I know that there are people who would dispute that as to it's possible for residual effects, and that it's not as benign as you just characterized, but that's not what, and in either case, it's not what we're discussing today, is it?
Yeah, a whole detailed account of how the taser works and the whole taser training. None of that's in an internal affairs review. That's correct.
I just was wanting to understand the difference between the two because of the escalation. It sounds like an escalation to deploy probes.
Yes.
So there was a choice to escalate in the final application, I guess.
Is the probes.
Is the probes.
Correct.
Okay. And the complainant, he was being apprehended because of his perceived aggressive behavior, not necessarily what may or may not have transpired with the driver earlier. Is that?
That's yes, his interactions with the driver initially, correct.
But I mean, if he had just not seemed aggressive at all, would he still have been taken into custody?
Well, if he wasn't aggressive at all, I mean, I'd still expect the sergeant and the officers to contact him and try to figure out what happened, if anything, between the complainant, well, the person in the car,
Yeah.
and the complainant in this case, try to figure out what happened. And then if he was, in my opinion, not resistive and they could have had a conversation, who knows how it would have ended up.
Okay. Thank you.
Mayor, I have one more question, and then I hope we have a chance to bring the chair of the CRC back. for a
Absolutely,
second.
you bet.
Chief, could you provide just a little more description for us of what you believe is the critical distinction between active aggression and resisting arrest? So where's that line? And help us understand the difference.
Well, the way we teach officers, and I'll just read it for you again. So out of our directive, at the time that this case occurred, So it's active aggression is a threat or overt act of an assault, and again, through physical or verbal means, coupled with the present ability to carry out the threat or assault, which reasonably indicates an assault or injury is imminent. So active aggression. So somebody, I'm trying to think of a hypothetical for you. If somebody, has clenched fists or sweating, they're running away, and I say, hey, come, I need to talk to you, and they don't, but they turn, and they're clenched, and they're looking for different ways of escape, and they might verbally say, get away from me, I'm not going to be taken into custody, and they're tense and clenched. Approaching that person is a whole lot different than, I've talked to other folks, hey, you're under arrest, and they go, okay, and they actually turn around and put their hands behind their back. I mean, they're two wholly different scenarios to where, based on their verbal comments, if any, their body stance, if any, the situation at hand, what the person in the car stated happened, you have all those together, and that builds up to where, in your mind, would this person potentially be violent or not? And if they, like the directive states that we train people, if you think they're going to be actively aggressive, you can go up to that level. My assertion in this case, though, with the video is on the ground, kicking an officer off him, to me, is actively aggressive, or pushing up, trying to not be taken into custody and trying to get away from the officers. To me, that's an overt act that you're not complying. I apologize that it's not a bright line on or off. I mean, there is a sliding scale, if you will, in there, but I think on this case, getting kicked as an example, to me, that's clear cut.
I'd like to ask a question about the Police Bureau's finding. Exonerated, but with a debriefing. Can you explain that in layman's terms? What does that mean exactly?
Sure. I think it's on one of the footnotes I sent with my statement, but exonerated, so unfounded would be just didn't even happen. Exonerated is it happened, but debriefing is, these kinds of cases, I would always suggest debriefing, because I think you can always learn from everything. So debriefing is a discussion. Sit down with all the parties and discuss why'd you do what you do at what time, and go through it and relive it and debrief it. What could you have done better? Other options you could have used. So just saying, yes, your actions are within policy. I think it's always beneficial to have a debriefing of what I just stated. Even, on all these, frankly. I always think it's good to sit down and reassess actions on any incident of this nature. So that excuse me, that added notation of with debriefing is just that. The officer, the sergeant, and their command sitting down and essentially kind of going over what we're doing here today.
So without bias, I'm just going to ask the following question. Would it be fair to say that the finding is, from your perspective, he acted within Bureau policy, but it was sloppy?
No, I would say it's he acted within policy, but it's good for all three of those members and their command to sit down and go, and with each one, why'd you do what you did? Could you approach it differently? That was a tool being tested at the time. What can you learn from that? There's, I can't think of any situation to where you can't learn and do a better job. Even if it goes well, you can always do better, right? That's kind of my philosophy. So it doesn't hurt to sit down and debrief. So I wouldn't say in policy, but sloppy.
Would you say that it was within policy but not textbook?
That's more subjective. In policy, but not in textbook. I think Sergeant B, his all his actions were exonerated. I think he did what he was trained to do. Having him try to take control of the complainant with 3 people, I think that's appropriate, and that's textbook. When you get kicked, you go back and help the other officers and try to trap his legs so he doesn't kick you again. I think that's textbook. So
and bear with me for one more question, colleagues. I appreciate this. I'm just trying to make sure I understand the totality.
There's a lot to this.
Okay, so we're talking about a 15-second period.
Right.
And it is your contention that this individual, we're really talking about Officer B, that Officer B used their judgment over that 15-second period and was within Bureau policy?
Yes, I believe he was.
Thank you.
Thank you.
Can the act of tasing produce the reflex that you, or was perceived as aggression on behalf of the complainant?
No, it would not.
So the involuntary kicking or anything like that would not be a reaction to being tased?
No. One of the big issues, and I saw it on TV last night, TV movies, somebody gets tased and they pass out. I mean, it's just horrific. That's not what happens. I've been tased where it went through my whole body, and you lock your large muscle groups lock up, and you don't move. Once it's stopped, again, zero residual. I can get up and go instantly. So the involuntary motor motions of like kicking, like you saw in the video, would not occur.
Again, I do think that could have other own, but I don't see anywhere in the Taser policy where it says how often it may be discharged in a minute or in 5 minutes. Is it in a different part than the policy?
Oh, how often a person could?
Well, yeah, I've got policy 105.1.00 electronic control weapon system, and it says when it may be used, but it doesn't say anything about how often. Is there another policy that says you should not use it more than X times in a minute?
No, well, no, there's not a policy that says you shouldn't use it more than X times in a minute. But the current policy is if you use it 3 times, like was used in this case, the new policy states that triggers a whole other set of protocols, but we don't have for our various tools we have how many times per minute an officer can use them. We just don't approach it that way. Again, on this one, if you try the drive stun twice, it's not effective twice. I mean, you should be thinking something different, whether that takes 30 seconds or 3 minutes or 3 seconds.
Which really goes to the mayor's point in that it was used many times, more than 3.
Well, again, my assertion is even though it was recorded, the computer chip in the Taser was recorded, I believe that, again, if you watch the video and you see that bright light and that Taser's up in the air, that's that drive stun mode. I believe the officer's inadvertently hitting that button because that's where his finger is out of the trigger guard. And yes, it's being activated, but I don't think it's necessarily, in my opinion, it's not a contact with the complainant. That's why I believe the officer thinks he did it 3 times instead of what the Taser download computer chip reads as 6 activations. He has 6 activations, but the officer is thinking he actually had contact with the subject 3 times.
And that seems to conflict with some of the witness, not the police witnesses, but the civilian witnesses who report more than 3. Maybe I can clarify that with the CRC. Thank you.
Thank you.
Any further questions for the chief? Thank you, sir.
Thank you.
Can we invite the chair of the CRC up for a minute, Mayor?
Yes, please. Come on up.
And while we're waiting for the chair, I have a question for council. Mayor read some instructions at the beginning of the hearing and analogized this to a land use hearing. And I guess we're all waiting for him to say, does anyone have any ex parte contacts to disclose? Does that not apply to this proceeding?
I'll refer to Heidi, but I believe the answer is no in this case. Heidi?
Yeah, she's checking.
Oh, thanks.
That's part of the instructions we get in land use, so I just want to make sure we understand what the rules are.
Could you speak into the microphone, please?
So the advice from council is that
You need to push the button because the voice. Just push it and let it go.
Yeah.
All right. Oh, good. You got the one that doesn't work.
There it goes. Good.
Sorry, I thought green was going. So then the question regarding ex parte communication would be that if you've had ex parte communication regarding this matter, you would disclose the fact of such ex parte communication, not the details thereof, and then you would disregard any of that information and state that you will disregard that information for purposes of consideration of your ruling and decision. in this
And when do
way.
we do that, at the end of the hearing?
Yes, I think that would be appropriate at the end of the hearing to do that.
Okay, very good. Thank you, Commissioner.
Prior to making your decision on it.
Very good.
Thank
Thank
you.
you.
Madam Chair, I have a couple of questions.
Sure.
There are 11 members of the CRC, correct?
Yes,
Under your bylaws, what is a quorum?
5.
And so the 4-to-1 vote would then meet the quorum requirement.
Correct.
Is that a sufficient quorum in your judgment? 5 out of 11?
I don't know that it's ideal, but for 11 volunteers, I think that's probably the lowest possible number that would seem fair.
But wasn't this heard when you only had 9? We've recently increased it to 10. Or 11, rather.
We had 9 several years ago before I joined.
Ah.
We've been at 11 since I joined, but for a period of time, we were short a couple members while we awaited recruitment after some
I
people
didn't mean
resigned.
to interrupt. Thank you.
Second question I have for you is, in reviewing the voluminous record that we got on this, one of the things that struck me was the number of times this came back to the CRC and the number of sort of procedural hiccups along the way. And I wanted to give you a chance to respond to that because this has taken a very long time to come to us. There were some back and forth about what's the right directive and was it being applied, and could you offer some advice and guidance to us about the procedural history of this case and what we can learn from that?
Sure. I think this case has become kind of the poster child for delays with the CRC process. Not long ago, City Council kind of commissioned a focus group to work on expediting CRC appeals, and the complainant was actually part of that group and provided some of his own opinions. But I think that this case is a really good example from the CRC's perspective of how much of that timing is out of the CRC's control. I think if you will look at the reasons this came back and back again, the Bureau, in our opinion, and I think rightly so, didn't complete an investigation. We had additional questions about the Taser log as well as witnesses that weren't interviewed that the Bureau did then go back and re-interview. But they're supposed to have 10 days to do that, and it took much longer than that. Then we convened for an appeal, and it was the Bureau who didn't show. The volunteers were present and ready to hear the appeal, but the Bureau members were under instructions not to attend. And then we went through a whole appeal hearing under the wrong directive, which was selected and evaluated by the Bureau. And although there was some complaint about that during that appeal hearing, the kind of verdict we received from the city attorney and the Bureau was that it was the right directive, only several days later to discover that the appellant was correct and that the case had originally been evaluated under the wrong directive. And then additional time is taken when we disagree with the Bureau because there's a kind of procedure for us to meet again with Chief Marchman and see if through dialogue we can agree on a disposition that would prevent us from coming here.
And you did, in fact, on one of the 2 issues, get to a disposition.
We did. But on this final complaint, it proceeded to you, and that kind of conference process of having another meeting to talk with the chief about it after we've already made our decision elongates the time as well.
Well, I would say that these kinds of cases don't come to the council very often, and I was struck by the procedural history, and I think we have to be very careful about the demands that we make on citizen members of committees like this and the amount of time and energy that goes into these cases, and we have to find a way to do this in a more expedited way and in a way that I think it just has a more common sense. It just, I felt your pain as I was going through the record of the procedural history of the case. The chief was just before us, and I guess probably a number of us are now a little confused about what is the standard of review. And we are now been told there might be a difference of opinion on that. What's your view?
My understanding, and I think my understanding of what the chief was trying to get at was that our committee and you all are supposed to be fairly deferential to the finding reached by the Bureau. They get a preponderance of the evidence standard, so they're kind of a more probable than not, was this within policy? Whereas you and I have to evaluate on whether that finding was a reasonable one, which is, it gives you less license to insert your own opinion. And I think what Chief Marshman was talking about was pointing out that there were several other players in the review process who, using the more generous standard of review, had also concurred with what the Bureau's finding was. So I think it's fairly well settled that supported by the evidence or the reasonable person standard is what you all are supposed to be using.
Even if we were to disagree with the ultimate judgment.
Yes.
Could I ask a question related to that, Commissioner, unless you had other questions? So the chief showed us a number of very grainy videos, and it is the contention of the Police Bureau in their findings that the individual was not restrained and was engaged in active aggression, and he pointed out some points in the video where he said, the individual was actively avoiding being arrested. He knocked an officer over. He was trying to do push-ups or whatever. What's your comeback to that?
I think that we had an interesting insight into this particular directive because we reviewed the wrong directive first, and when we reviewed under the wrong directive, we agreed with the Bureau, mostly because we felt that that directive allowed the taser to be used in the case where someone was trying to flee or resist or be somewhere less than what it is now, which active aggression, I think we need to focus on the definition in the directive, which is a threat or overt act of assault. And I think that listening to the chief say it, there is, to him, restrained, meaning completely passive and calm. The officers could have gotten up off of him and he would have laid there passively. And assaulting somebody. And in between that, I think, is where the CRC found that he was resisting, but that resisting was not active aggression. And I think when you look at the kicking, in light of the video that you all watched, the kicking occurs right as he falls to the ground. He's been tased and he's kind of flailing. But then in order to apply the drive stun to the calf of the appellant, Officer B has to get hold of his legs, and he's holding the one leg down, which is kind of crossing over his body in a way that is really pinning him to the ground, and he goes into the calf. And then when he goes to deploy the probes, at that point he's straddling and he's got a knee on him, and Sergeant A is straddling, and it looks like he's almost asking the other officers to make sure they move out of the way so that he can deploy the probes and not hit them. That to me is what appears on the video.
So after several years of reviewing this, it sounds like you're saying, yes, he was resisting arrest, but he was not engaged in active aggression. And what we're hearing from the officer involved is he felt there was a threat. I think the police chief said it looked to him like somebody might throw a punch. There's some grainy videos that would probably make the worst hits of YouTube if they were put out there under a standard. What advice would you give this body, given that the standard that we are required to act under is, could a reasonable individual have made this decision based on the evidence that's available? What advice would you give us as the CRC chair?
I would say first that I think the community especially has been concerned locally and nationally over officers' subjective accounts of fears or threats of assault. And when you see the video here, I think that that's very good evidence that the subject was in fact restrained at the time. And I personally would look to the last discharge of the taser. I think we heard Chief Marchman talk a lot about discharges in the air and maybe some of the activations in the middle didn't come into contact with the appellant. But we know that the sixth discharge occurred after he had deployed the probes. So anything that's coming from that taser is going directly down these wires and into the appellant. And it seems pretty undisputed to me that he had no justification for that activation, that it was simply an accident resulting from the design of this new taser that caused him to flick the button completely inadvertently.
So the video does appear to show some flashes. What do you think that means? The chief gave one thought in terms of what he thought that meant. What does it mean to you, if anything? And it doesn't have to be anything.
I don't know, from my perspective, that it changes the analysis much. We know that there was a drive stun when he was standing and that he fell. We know that there was a drive stun in the calf when he was on the ground. We know that there was a probe deployed into his back. And those three activations are not disputed. We know that they occurred, and we know that they made contact with the appellant. And at least before this hearing, we had not heard the Bureau dispute that the last activation occurred while the probes were still attached before the medical personnel came and removed them from his back.
So he was, according to you, resisting arrest. 15 seconds go by where some number of charges are deployed directly to the complainant. I think in his testimony he said at least 3 times. So we're disputing the number of times, aren't we?
I think to me, it's clear that there's a minimum of 4. There are the 3 that the officer reported and the one while the wires were attached that showed up on the taser log.
Okay.
So whether or not those 2 were in the air, 4 to 6, I think is probably what we can say from the log and the video.
Thank you. I appreciate that.
Do you have any other comments on any of the questions that have come forward and maybe things that the CRC discussed?
I can clarify for you witness officer C and D. Witness officer D is actually the partner of officer B. For some reason, the order got swapped. Witness officer C was the officer who contacted the driver of the vehicle. So that officer's statement concerned her report of what happened around the car. That was not an officer that was standing around watching the incident on the video transpire.
And was there any discussion in the CRC of the initial use of force, attempting to put this person in handcuffs?
I believe there was, related to another allegation, but I didn't refresh on that for this meeting. And I would suspect that if it did come up, that there was significant evidence that the appellant was putting his hands into his pockets and throwing things on the ground. I think the appellant said that he wanted to show his driver's license to prove who he was and that he wasn't homeless. But Sergeant A was worried that there was a weapon or something like that in the pockets, and there wasn't a response.
And we've heard a lot of discussion about the standard of review and the reasonable person versus preponderance of the evidence. Based on that knowledge, how often does the CRC have a majority saying that, yes, there is a reasonable person would not have done that or concluded that?
I wouldn't say it happens terribly often. There have been times where we've tried to add a debriefing where something happened maybe in line with what Mayor Wheeler was saying, where, this was within policy, but it was sloppy. This was not the ideal way that we would like to handle this. And then we've had a couple occasions where we have challenged, and the Bureau has accepted our challenge, either without a conference hearing or after some dialogue with the Bureau. We've come to see eye to eye.
I guess I had just one follow-up, and since we've never had a hearing like this before, I just want to say that I appreciate that you in your role as the chair of the CRC are playing an invaluable role in helping the council understand the CRC's position and walk us through it. We're sort of making this up as we go along, but I appreciate very much your presentation. The chief, toward the end of his presentation, talked a little bit about the higher use of force. And I guess as I understand the argument is that it may have been, in the context of what was going on, might have been a different case if someone had used a baton or a fist, that in fact it was just a taser. And I want to think about that, but what was your reaction to that?
Well, well, I would say 6 of the new CRC members 2 years ago had an opportunity to attend the Citizens Police Academy. And the officers there who had been tased during their training, I think they can voluntarily elect to be tased to see what it's like, almost all said it's an experience they would never want to repeat. And I am not sure I am as persuaded by the concept of it being brief or it not leaving a mark when talking about the amount of pain experienced or the kind of trauma it can leave behind. But I'm not sure that from the evidence we saw that an escalation in force was needed. It seemed like especially once the subject was on the ground, the officers were in the process of getting the appellant under control. I think perhaps time would have been the best remedy there. I wonder if the Officer B had evaluated the situation before he deployed the probes. He might have seen that there wasn't much of an out for the appellant anymore at that point in time, and it was just a matter of time before they got his hands together and could proceed.
I apologize. I'm not sure if you are the right person to address this question to, but the complainant has indicated that he's a traumatic brain injury survivor and that he experiences mental illness. And in the last several years, I know police policy and training has changed around interacting with individuals experiencing mental illness. This situation escalated quickly, clearly. The complainant appeared to be afraid and perhaps panicked, based on emptying his pockets, asking what he had done, saying he wasn't homeless. I can imagine why he said that. Can you comment at all on what we would hope or expect an officer to do when encountering someone who may be experiencing some kind of crisis or just ongoing mental illness?
The CRC has convened a work group and had voted recently to support a report that would prioritize de-escalation whenever possible. I think that the concept of de-escalation we've seen has kind of appears sporadically through police policy, but cities like Seattle have an overarching policy emphasizing de-escalation, and I would hope that with a more de-escalation based policy, you would not see the officers escalating the situation so quickly. I think that there might have been a better way to back off instead of advance and go immediately to force. I don't think that decision at the time was out of policy, but there's a policy that we wish we had and a policy that we have.
Thank you.
Thank you.
Are there any further questions of this panel or anybody else? So colleagues, we have had at least one commissioner ask that we go into executive session to meet with legal counsel. And I set a standard earlier that if anybody felt that that was an important thing, that we would do that. We will come back into open session, obviously. But for the time being, we were. Did you have a question?
I believe your city attorney, David Landrum, needs to disclose ex parte communication calls.
So why don't we do this now?
Left voicemails and I have them.
Okay, sir.
Yes.
Why don't we do this now so we take care of this council, which is the decision-making body?
Advice and he didn't disclose. He called me personally.
I will ask legal counsel, if you'll give me a moment. Legal counsel, we are going to, in a moment, disclose any ex parte contacts we have had. Is there a commensurate requirement that city attorney disclose their ex parte contacts?
My understanding, what I hear Mr. Klug talking about would be an interaction that happened related to the civil case. That matter is not before this council and is not part of your consideration for this issue of whether you find evidence to support the chief's finding in this situation. So that particular would be a separate issue unrelated to what's before you today.
All right, thank you.
Mayor, I'll kick it off.
Yeah, please.
We received a couple of emails relating to this matter. I believe one was from the complainant, and I did not review that email, just forwarded it on to my staff person. I had a brief conversation with Dan Handelman, who is something of a historian of police accountability matters, and he reminded me we've not had such a hearing since 2003. And that was largely the extent of it.
I received the email also from the complainant, which I did read.
Excuse me, sir. You're out of order. No, let us finish this order of business, because you are the complainant. I will let you address the council, but for the time being, let us do our business here. I have no ex parte contacts except the email that was referenced earlier. I did read the email.
Same, I received the email, I read the first paragraph, then realized it was relating to this, and so I waited till I could ask the city attorney as to whether I was supposed to be reading it. I also meet regularly with Julie Ramos, who's the co-chair of the CRC. I haven't been meeting with her since I knew this was going to be on the council agenda, so we certainly haven't discussed the specifics in this case, although when it first came through, it may have been one of the ones that she talked to me about in general.
Commissioner Daly.
I received the email but did not read it, and have had no other communications about this case.
Very good. So the city council has made its disclosure, sir. If you wanted to come up.
Do you know anything about the communication?
Could you please reintroduce yourself for
my
the
name is
record?
Matthew Klug.
Thank you.
And I'm just curious if you guys have any clue about the communication I sent. Because if you didn't read it, there's a big problem. The Tort Review Board wanted to get to the bottom of my complaint in federal court, District Court of Oregon. And inside the District Court of Oregon complaint was the video that I received from a civil rights attorney here in town. And I've got the video with audio, so it would be beneficial to look at the copy the Tort Review Board was interested in get to the bottom of.
So here's the problem, sir, with regard to this hearing. We are not allowed to entertain new evidence. We are unable to do that.
No, that was the evidence.
I will ask the city attorney whether or not we are allowed to consider new evidence.
You are not allowed to consider new evidence. You are allowed to consider the evidence that was in the record at the time.
Correct.
The video was in the record at the time.
The video is in the record. The copy of the video that's in the record is running on the internet at klug.pw. It is very visible. It's not cloudy and choppy like the copy they have. It has audio. It would be beneficial to look at the copy that the Tort Review Board was interested in reviewing at the Internal Affairs and an independent police review. Otherwise, we've got the policy. And to answer Amanda's question, the number is in 2.4. It's on the second page. And then the first charge of the taser at 3.8 was up in my face. So in the written report from the cop in the narrative, it says, warning arc. There's nothing in training about a warning arc. And then you see me fall to the ground, and if you watch the video and my good copy on the internet, I cover my face, and this is all in the record.
I don't mean to be disrespectful, but I have to give everybody...
It's 30 seconds long, too. And so, but 6 charges of the taser go off. They're limited to 5 seconds each.
Sir,
so that's 30 seconds.
I can't allow you to continue. I'm sorry.
But that's the video. It's the basis of the whole thing.
City Attorney, that version of the video is in the record.
I'm not sure of what Mr. Klug is referencing. There is a version of the video that is in the record that I'm sure we could get and make available to you. I don't know what Mr. Klug is referring to, and I haven't seen it, so I can't say.
So I think that is germane to what we have to decide. We have to decide whether a reasonable person, considering the evidence, could make a decision.
The one with
so that
audio.
has to be evidence. And thank you, Mr. Klug, for telling me, in fact, that yes, in 2.4, it does say members should evaluate their force options and give consideration to other force options if ECW is not effective after 2 cycles on the same person.
Okay,
Thank you
and
for
so
that.
we gave the complainant approximately 2 extra minutes, and for that reason, if the Portland Police Bureau would like 2 extra minutes in the interest of fairness, I will offer that.
Mayor,
Back
can
to
I-
the ex parte thing, though,
Excuse me,
please.
sir.
May I address the
Sir, you're
council?
out of order. No, you may not.
Mayor, in the packet of materials that we were given in advance of this hearing, we were given a DVD. And that as I understand it, is the DVD of the video in question. Is that correct?
Of audio.
I believe that's right, but I think IPR put the package together, and we could double check with them. But I believe that is correct, that is the CD that has the video in it with everything on it. That was considered as part of the record.
Okay, and the Police Bureau has declined the extra 2 minutes, is that correct? Okay, good. So we will now adjourn into executive session. We will be back. So we are in recess.
One moment.
You need to read
Thank you.
What about
Fairly-
Landrum calling me, though, personally? I mean, I'd love to discuss that.
Okay, so here's the script. The City Council will now adjourn to the Mayor's Conference Room to meet in executive session pursuant to ORS 192.6602B, which allows City Council to meet in just wallow through this, which allows the City Council to meet in executive session to consider the dismissal or disciplining of, or to hear complaints or charges brought against a public employee who has not requested an open hearing and pursuant to ORS 192.6602F, which allows the City Council to meet in executive session to consider information or records exempt by law from public inspection. Representatives of the news media and designated staff shall be allowed to attend the executive session. Representatives of the news media are specifically directed not to report on or otherwise disclose any of the deliberations or anything said about these subjects during the executive session, except to state the general subject of the session as previously announced. No decision may be made in executive session. At the end of the executive session, the council will return to the open session in council chambers. The city attorney wanted to speak?
Yes, Your Honor.
Yes, sir. Please introduce your name for yourself
Mark
for the record.
Ambert with the City Attorney's Office.
Thank you.
The procedural point, ORS 192.6602B, one of the bases for going into executive session allows the involved employee, the officer in this case, to request that the executive session be held in open session. And I've had a communication with the representative for the officer, and the officer does not want to have the matter deliberated in open session. So
Very good.
I needed to state that for the record.
Okay, thank you. So we are in recess. All right, good afternoon, everybody. We are now out of executive session. We're back into regular session. I've had a request if we could have legal counsel once again come up and walk the council through our options.
Thank you, Mayor and Council. Again, Mark Amberg of the City Attorney's Office. When Council is ready to take this matter up on a vote, it's potentially a two-step process. The first vote the Council has to consider is whether to accept or reject the finding by the Bureau. And again, that's based on the reasonableness standard, whether a reasonable person in the RU manager's situation, the RU manager who came up with the finding of exonerated with a debriefing, could come to that finding based on the evidence. That's the first step. If council votes to affirm the Bureau's finding, that's the end of the council session, and that's the end of the case. That decision or that finding of the Bureau would be upheld. If council votes to reject the Bureau's finding, then you go to the second step of the process. And the second step of the process is council has to determine the finding in the case. Again, the four options for council would be unfounded, technically exonerated without a debriefing. Council could come to that conclusion. Not sustained or sustained. Does council want me to explain again what those four
Why don't you
standards are
quickly
for
do that for everybody's benefit?
So unfounded basically means that there's no basis in fact to that the event occurred. I look at that as the allegation is Portland Officer Smith did X when in fact it was Officer Jones from Gresham. Well, that's an unfounded finding where there's no basis in fact for the allegation. Exonerated means the act occurred with the claim that what the officer was claimed to have done happened, but it was lawful and it was in policy. It didn't violate the Constitution, didn't violate other law, and it was also within the Police Bureau's policy. For not sustained or sustained finding, those are, again, the council will weigh those findings, if we get to that point, on a preponderance of the evidence on a more likely than not basis. And for sustained or not sustained, council would need to make a determination whether it's more likely than not that the officer's actions either were did not violate policy, in which case it would be a not sustained, or that the officer's actions on a more likely than not basis violated policy, in which case it would be a sustained finding.
That's not right. You're wrong.
All right.
Okay. Any further questions of legal counsel?
Ready for motions?
And just to try to clarify that last point, again, sustained means the evidence was sufficient to prove a violation of policy or procedure based on the preponderance of the evidence standard. Not sustained is the evidence was insufficient to prove a violation of policy or procedure, again, based on the preponderance of the evidence standard.
Commissioner Udaly, did you have a question?
I was just going to ask.
Okay, good. So at this time, I will ask if any of my colleagues have a motion.
I have a motion. I will move to uphold the chief's finding to exonerate with debriefing.
So moved. I'll second for discussion. Commissioner Saltzman or anybody else have any comments on this?
You know, I just don't have, I can look at the video all day long and I can't tell what's going on, but I know it's a very brief episode. I believe the complainant and his account, but I do believe that there was, I do tend to agree with the chief in terms of perhaps not misfiring of the taser, but too rapid of firing while the taser was a distance from the complainant's body. So the taser, if it cycled 4, 5, and 6 times, it didn't necessarily hit the complainant, or I should say 3, 4, and 5 times perhaps. But I guess long and short is I feel I'm listening to different accounts of the same incident, and I don't draw any conclusions from the video. I just can't, and so I'm going to err on the side of exoneration with debrief.
Mayor, may I be heard?
Yes, Commissioner.
I'm going to oppose the motion, and then I'm going to recommend an alternative approach if the motion fails. This is the first hearing of its kind that I've participated in, and I spent quite a lot of time wrestling with the materials that I was given prior to this hearing, but I found the hearing itself very helpful and very clarifying. We are admittedly applying a very deferential standard, and we are being asked to determine whether the judgment of the Bureau fits within a reasonable person standard. And I believe the law is clear that we have to be very deferential, and I think the chief has come very close to making out that standard. But there are too many unique circumstances in this case that trouble me that I think need to be aired out and discussed. And I don't think the council can have that proper discussion if we simply accept the findings. So I will oppose the motion, and then if this motion fails, I will make a substitute motion.
Very good. If there's no further comment, I'll ask Carly to call the roll.
Fritz.
Yeah, I can't support the motion either. It's very clear that policy 3.2 and 2.4, the analysis by the CRC, I believe, is supported, and that a reasonable person would not exonerate. So, no.
Fish?
No.
Saltzman?
Aye.
Udaley?
No.
Wheeler?
Yes, and I want to explain my vote even though the motion fails. The standard, as has been discussed here by my colleagues on both sides of this issue, is a difficult standard. The question is, could a reasonable person have made the call that they made given the evidence that's been provided? And the evidence that's been provided is not rock solid. Unfortunately, what we have, as I mentioned, are different accounts, grainy video, judgment calls that were made over a 15-second span, and differing questions around standards such as, was the individual restrained or not? And again, we're relying on both testimony as well as a grainy video. And the question of active aggression. Was the individual engaged in active aggression? He says he wasn't. I have no reason to doubt his opinion on that. But on the other hand, I likewise have no basis to doubt the opinion of those who made an alternative judgment. So for that reason, I support it, but the motion fails. Commissioner Fish, I think, was going to make an alternative motion.
Thank you, Mayor. We are now free, based on the preponderance of the evidence, to recommend an alternate finding. For many of the same reasons, Mayor, that you've just articulated in support of your earlier vote, I am very torn by the evidence before us. I am troubled by the documentation of 6 different tasers. I am concerned about the mental state of the suspect, who appeared to be in crisis, and frankly, reviewing the video makes that a little more clear. And I am, frankly, struggling with where that line is between active aggression and resisting arrest, and the sort of objective and subjective standards that you could apply to resolve that question. At the same time, as you note, Mayor, this happened during a very quick time frame. It unfolded quickly. And I think the chief has made a point in reminding us that this encounter did not lead to a higher use of force, which would have led to an entirely different investigation and proceeding. Because I find it difficult to resolve the two competing versions. While I could not support an exoneration with debrief, I will make a motion to have this matter not sustained.
Commissioner Fish moves to have the issue not sustained. Is there a second?
Second.
There's a second from Commissioner Udaley. Further discussion? Carla, please call the roll.
Fritz.
I appreciate the attempt for a compromise. I still support the CRC's report, and I'm very troubled by many of the other things that I'm reading in the record, which are not part of this case, but which I'd like to follow up on. No.
Fish.
There are a number of things that have been brought forth in this record and in this hearing that concern me and others. I am loath to second-guess officers who are making split-second decisions in these kinds of circumstances. I'm reminded of advice that Commissioner Fritz often gives us in land use proceedings about the requirement that we follow the law and the directions, and that we are scrupulous in adhering to the standard of review that we're supposed to apply. Because we're now operating, I believe, under a preponderance of the evidence standard, I just find it almost impossible to reconcile the two accounts and to adequately address this question. So I will use this opportunity again to just state the concerns that I have. I believe that with three officers attempting to subdue an individual who in this case gave some evidence of being in distress, I think that in our protocols and our training, we should continue to emphasize de-escalation. And while I appreciate that the chief has drawn a distinction between using a baton or a fist or, God forbid, something else, to a taser, I don't want to minimize the impact of using a taser on another human being. And the fact that it was used 6 times, whether accidentally or not, troubles me greatly. And I must say, I think this distinction between active aggression, which the tape I don't think really adequately resolves, versus resisting arrest is a very fine line. In fact, I think you're likely to get different outcomes depending on whether you use an objective or a subjective standard. So I mean no disrespect to either the complainant or to the Bureau, but under the circumstances, I cannot get to a preponderance of the evidence, and therefore I must support a not sustained.
Okay. Aye.
Saltzman.
No.
Udaley.
I agree with Commissioner Fish on this matter. It's problematic to me that the evidence doesn't constitute a clear violation of policy and procedure. That's something that we have to deal with down the line, and just agree that while I can't clearly vote one way or another. Not sustained seems like the only course of action. Aye.
Wheeler.
For the same reasons as previously, I vote no. The motion fails. Colleagues, are there any more motions that anybody would like to make before we open the windows and see that there's 36 inches of snow outside?
I hope not. Is it snowing?
I wouldn't be surprised.
Well, if we can't reach a consensus, that's it, isn't it?
If we don't come to a consensus, to be clear, and legal counsel can confirm this, then the finding is effectively upheld by default, is it not?
The findings of the CRC or the findings of the
Police Bureau, I believe.
But I thought we voted to reject the findings.
Could you come up here and clarify this, since we're now in new
Seem to
territory?
be in limbo.
Yes, we're in new territory again.
Ben Walters with the City Attorney's Office. So at this point, do You still have the other three options that you could consider that were described by.
And we understand that. What's
Yeah,
the
what
effect
if,
of
what
what
if
happened
nobody
right now?
has a motion?
There's no other path forward as I can see. So what's the effect of the last vote?
The effect of the last vote is your motion, of course, fails. If you can't come up with a majority, then effectively you have the decision of the chief stands.
But I thought the earlier motion overturned that.
I understand that, but you're unable to find a pathway forward to another finding at this point in time, is
So if
what you're
that's the
telling me.
case, I think I was in the majority with that motion because it failed, so
It
I'll
did.
move to reconsider.
Second.
So we need to vote on reconsidering it, and then I will change my vote.
Please
Please
call
a
the-
vote to whether to reconsider.
To reconsider the vote on the finding
The vote of
of
aye.
matter not sustained.
I would give Commissioner Fritz a chance to vote again on this motion.
Correct. Carla, could you please call the roll on the reconsideration?
Fritz,
So for those struggling at home, that motion failed. I voted no, so I was in the majority, so that means I can move to reconsider, which is what we're doing here, is basically taking that vote again, doing a do-over. Aye.
Fish.
Aye.
Saltzman.
No.
Udaly.
Aye.
Wheeler.
No, the motion passes.
So now I move, again, Commissioner Fish's motion if not sustained.
Is there a second?
Second.
Commissioner Fritz moves, Commissioner Fish seconds. Carla, please call the roll.
Fritz.
I think what we have to remember here is that there's a lot of people who are trying to do the right thing here. There's the person whose car was banged into, there's the appellant, there's the officers involved, that it seems like many of them got kicked and otherwise hurt. There's the passers-by, there's a lot of people, and then there's the review bodies and the Citizens Review Committee who have put a lot of time into trying to figure out the best way forward on this. So I'm changing my vote because I don't think we should just allow the chief's decision to stand. I do think I know there are a lot of other issues that need to be considered in connection with this case. Particularly pleased, as part of the evidence here, I've been given the actual timeline of how this case took so long to get to the appeal. And that's an issue that we have to deal with Department of Justice settlement. So I'm glad to have a specific example. And as I say, there were many people who were hurt by this. And there's many follow-up things that we need to do. I do think that the officers should be counseled, that we need to, I can hardly wait to see what the latest use of Taser policy is that isn't even in the record here. So that's something else that we should be looking at. And so a not sustained seems to be better than allowing the chief's decision to stand without further conversation. Aye.
I've already spoken to this motion. I'll just add one other thing, just to be clear on the record. Some may leave this hearing today wondering what is the practical difference between exonerated with debrief and not sustained. And so I will just provide, again, my interpretation of the difference is that as we have struggled to apply a standard of review, which is very restrictive, and to reconcile facts that are sharply at odds and to consider broader policy questions, this, I believe, is a principled way that a majority of us can express concern with aspects of this case, and I would hope that those concerns would be reflected in future training and protocols. Aye.
Saltzman.
Well, one thing I will agree with Commissioner Fritz, this case has taken entirely too long. It's ridiculous. I vote no.
Udaly.
Aye.
Wheeler.
So I'm going to stick with my first statement, but I want to add a few comments as well. First of all, I want to thank the members of the CRC. They spent a tremendous amount of time reviewing lots of evidence, grainy videos, came to a principled decision. I want to thank everybody here who testified today. I also have to say this, while I support all of the broader principles that have been discussed here today, how the police interact with our public, how we treat people who are potentially vulnerable in the community, including those with mental health issues. I raised some concerns around training standards that are still of interest to me. But when it comes back to what this hearing actually is about and the facts of this particular case and the standard by which I am being asked to judge it, which is, could a reasonable person with these facts have come to the conclusion that they did, though inelegant, for me personally, I have to answer that question in the affirmative. So I vote no again, but the motion does pass. And with that, I believe we are adjourned. Thank you.